everyone ready? Sorry to hold you up. The series of announcements to make with regard to labor contract issues, and then after that I'll be glad to try to take any of your questions. About 2 weeks ago, on January 16th, I announced that after almost 4 years of trying to reach a collective bargaining agreement with District Council 33, that we were deadlocked, that we had reached an impasse. On that date, we also presented, as a city government, our final offer. It was a very good offer: pay raises for our public employees, pension reform for taxpayers, and more. Unfortunately, union leaders rejected our final offer, as they have rejected every other proposal that addressed furloughs, pensions, and costs related to overtime calculation. And yet, I'm also always hopeful, but I'm also realistic as well. And that's why I gave the union leaders 2 weeks to reconsider their absolute refusal to help us achieve pension reform and work rule changes that we need in order to sign a contract that is fair to our hardworking and dedicated public employees, as well as fair to the hardworking taxpayers who pay the costs of city government. With the final deadline looming, there were meetings on Tuesday and Wednesday of this week, just a few days ago. Unfortunately, those talks were completely fruitless. They went nowhere on our key reform issues on pensions and work rules, which we have been consistently advocating for, pushing for, and trying to attain from the start of our administration. In a document that the union leadership submitted yesterday, they said, and I quote from that document, "In the course of our negotiations, we have had discussions over the issues about which the city has taken the position it will not budge. The proposals in this document do not alter our present stance regarding those subjects, except to the extent they may be dealt with in these proposals." The shorter version of that is we are not making any changes or what they consider concessions on the issues that are directly important to the city of Philadelphia. Union leaders, as I mentioned, call these issues concessions: pension reform, work rule changes. And they have consistently vowed, privately and publicly, to make no concessions. In short, we are no closer to agreement today than we were 4 years ago. Well, this is what I have to say about that. The deadlock has gone on long enough. Union leaders have held our public employees and the taxpayers hostage to their Just Say No campaign. We can't let this stranglehold continue. It's not fair. It's not right. We need to move forward, resolve these issues, and get a fair contract signed. We need to move forward as a city with reforms that are critical to our fiscal health and accountability and integrity. 2 weeks ago, many of us were going about working on these issues, and we were asked what we were going to do since we had reached impasse. We said, and I said, let's give it 2 more weeks. Let's see if common sense and fairness can prevail. Let's give negotiations a chance. We're done with that. Today, I'm announcing that we firmly believe that we should have the right, on behalf of 1.5 million Philadelphians, thousands of hardworking, dedicated, and committed taxpaying citizens, to implement our final offer. Now, clearly, the union leaders will disagree, and you'll hear much from them, I'm sure, about that. And here are the facts. Rather than going ahead and implementing this final offer and having our hardworking city employees in a state of uncertainty about their compensation, benefits, and work rules, we're going to ask the courts to decide on that part of this matter. This morning, we already filed an action in the Court of Common Pleas, this is our filing, asking the court for a declaration that we have the right to implement this contract. During this period of litigation, the City will maintain the status quo on all issues that separate us. As we did 2 weeks ago, we've handed out materials that explain the terms of our final offer, that compare with the current terms, with the impact of our proposed contract on the quote-unquote average city employee, and some case studies of how our proposal would affect a sampling of active, actual, real employees. In addition, the final offer that we made to District Council 33 was a detailed chronology of our meetings with the union, and the documents we distributed today will all be placed later today on the City's website so that Philadelphians will have a very clear picture and understanding of what has transpired over these years. Our final offer is fair, it's reasonable, provides a real increase in take-home pay for City employees while enacting pension reform and work rule changes that help us to afford those raises and prepare for a more fiscally sound future. The final offer provides a 2.5% wage increase 30 days after any agreement takes effect and an additional 2% increase on January 1st, 2014. Employees will have their step and longevity increments restored prospectively, and the union will receive $25 million in 2 payments to support their health care fund. Taxpayers will see common sense reforms in terms of a new pension plan for new hires, coupled with a modest increase in pension contribution from current employees for a pension fund that is unfortunately only 50% funded. Those contributions will help to better ensure the fiscal integrity of the pension fund for all employees. And the taxpayers will benefit from new work rules related to calculation of overtime and the right to furlough employees if necessary due to economic circumstances for the City. That, of course, is in lieu of layoffs, which is one of the few options that we have in managing our employee costs. The City stands ready to implement this offer as soon as the Court rules. It will benefit our City employees, the taxpayers who pay the bills, our City, and its great future. Of course, we are always prepared and ready to engage in real, in serious, in meaningful, and results-oriented negotiations with the union leadership at any time. But the time for action is today, and that's why we made the court filing. Lastly, just for context, the last increase that these employees received was on July 1st, 2007. It is now February 1st, 2012. That's 5 years and 7 months. 2013, rather. It's 5 years and 7 months since their last raise. As best we can tell, that is the longest in modern history. And what's the holdup? That new employees would go into a different pension plan. That we would ask them to pay current employees to pay a little more into a fund of which all of us are members. That they might actually have less costs to their health care based on the $25 million contribution over 2 years. That we would recalculate overtime, that we would have the right to furlough rather than only the ability to lay off our employees as we manage through these still tough economic times. This is what the union leaders are holding our public employees hostage over. It is unconscionable. It truly is not fair to our employees or to the taxpayers of this city for this kind of circumstance to continue seemingly forever. So we're taking the action today in an attempt to bring all of these matters to a proper conclusion. I'd be glad to take any questions that you might have.
Mayor, could you elaborate on your personal decision in opting to immediately go to court versus imposing
As I mentioned, while we do believe that we have the right to implement, we also felt that it would create a certain level of uncertainty for our public employees during any period of litigation. And obviously, a more straightforward path, our attorneys are certainly here, they can elaborate if necessary, with the court's ruling and court's permission, that removes that level of uncertainty. And so that's why we chose to make the filing, go through the normal court process. We'll maintain the current status quo for our employees so they don't have to wonder what's going on. But we do believe we have the right to move forward, but we are seeking the court's permission.
Do you plan to implement, if you get an affirmative ruling at the common cause level, or will you wait till all appeals are exhausted this way the state Supreme Court?
As you know, Mike, I do try to do my best not to speculate on what is unknown. So I'm not going to speculate on what, when, how, and why. We just filed this morning. We'll evaluate our circumstance or situation based on what happens, at least at the first phase of a court process.
What is the status of your talks with City Council about actually implementing the hybrid pension plan? And roughly how many employees have already been funneled into the old plan because of council's failure to act?
On the first part, I've had relatively recent conversations with Council President Clark on that. The Council is evaluating the bill that was sent over. I think it is an active topic of conversation, but they're going through their own due diligence process. The second part, I actually don't know the answer to that question. We'd be glad to get you that information. Anything else?
Mayor, Pete Matthews objects to your use of the word taking the city hostage. He says the union workers have been coming to work without pay raises for 5 years, as you noted. So how is it fair to describe them as taking the city hostage when, in other
Well, I think it's unfortunate that the public employees who are hardworking and dedicated, I see them all the time. I think it is unfortunate because the union leadership cannot seem to reach agreement with us that they've not had raises for the last 5 years. We have 2 years of raises on the table right now and still can't get an agreement moving forward. So the taxpayers would also like the certainty of knowing that there's a contract in place. It helps us to better manage our limited resources. So the employees and the taxpayers are being held hostage by their inability to reach agreement on some critical and fundamental issues: pension reform, work rules changes, and the authority to furlough. I'm sorry?
That's a 4-year deal you're going to impose.
It's a 5. Yeah. Goes back to 2009.
Mayor, can you talk about the status of negotiations with
We've had a variety of discussions with District Council 47 over the past few months, and I believe that there are some sessions upcoming that are scheduled or being scheduled. We've stayed in touch with them.
Is the city in a substantially different place with DC 47 than it is with DC 33?
Yeah, I mean, each union is different. Each series of negotiations are different. I mean, so they're different. I mean, I'm not going to get into the nuance between them, but different unions, different discussions, different people involved.
But you don't believe you're at an impasse with DC 47?
The best thing for us, and yeah, the best thing. Well, if we were, I'd say that the best thing for us is to get back to the table, and that's, I mean, kind of goes back to the earlier question. We're looking forward to upcoming discussions with District Council 47.
They are prepared to labor that the court battle that you're initiating today will drag on for months.
I would hope it wouldn't, but I'm not in charge of the courts. Courts operate on their own schedule. We're hopeful to try to get a resolution as quickly as possible, but again, that's not an area under my control.
Do you have any clarification on the law?
I have no estimation. The courts take material. They operate on their own time schedule. Again, we think that this is obviously an important matter and would like to see action sooner rather than later. But again, I have no ability to determine that. Last question. I'm sorry?
Do you plan to testify when a common pleas judge holds a hearing?
We're nowhere near that kind of determination. We just filed this morning. Thanks so much. Bye-bye. I'm sorry? Not right now. Yeah, I've got an event that I'm late for. But if you have something else, you can work with Mark. I'd be glad to talk to you later. But I have to go.